Good evening. I'm John Miko, the Executive Director of the Union League Legacy Foundation. It's my absolute pleasure to welcome you to this very special Liberty Series program. Tonight we have a really wonderful program, all made possible many years ago by Jack Templeton, a league member for many, many years, and we're thrilled that you're all here. Jack made it possible. Many of our members here and others make it help to continue it. I want special thanks to Jefferson Hospital and Healthcare and Ed Trzanski, who has helped underwrite a good portion of our lecture programs this year. Ed, thank you very much for your support. The Legacy Foundation is the nonprofit charity of the Union League of Philadelphia, and everything that we do is inspired by that first line in the Union League bylaws. Every member shall support the Constitution and the free enterprise system. And tonight, of course, could not be a more appropriate topic to support that first line in our bylaws. But there are many other things we do throughout the year, including scholarships and civics education exhibits. And we care for this great collection, art, archives, and library of the Union League of Philadelphia. So thank you for all of you who make it possible. We are not supported directly by the Union League, but through voluntary support from members and others who share our values. So I thank you very much. We have just one upcoming program left for this season, which has been a very successful one. On December 1st, we have a Civil War Roundtable with Bill Kashutis. The subject is William Still and the Underground Railroad. We've had great success this year. You're all back, which is wonderful. We've had record attendance this fall, and we look forward to publishing our spring and winter program in the next few weeks. A few housekeeping items. First of all, if you could please silence your cell phones, we would greatly appreciate that. I'll take a moment to allow you to do that. We will have a Q&A portion to this program, and there should be a card on each of your seats, and please fill out the card with questions, and our staff will be around to pick them up, and we will get to as many questions as we can towards the end of our program. Tonight is CLE. You can get CLE credit for those lawyers out there, I will tell you what the word is at the end of the program. Am I supposed to say it now or at the end? Can't trust those lawyers. So wait till the end, and we'll give you that word. And now it is my great pleasure to introduce the chair of the Union League Legacy Foundation, Ms. Joan Carter. Joan.
John, thank you. Welcome to everyone. It is my great pleasure to introduce tonight's program, which is about the Supreme Court. You know, the founders intended that the Supreme Court protect the Constitution and the individual liberty that the Constitution guarantees, but also it was supposed to protect the stability of our republic through the rule of law. And to quote Alexander Hamilton in Federalist 78, somebody wrote that for me, I don't really know. But anyway, this requires, so he said, a secure, a steady, upright, and impartial administration of the laws. So this requires a court system that, yes, is loyal to the Constitution of the United States, and unlike the other two branches of government, that it not be subject to the influence of any political or financial interests. And in order to create this kind of a judiciary, the founders ensured that the Constitution provided a separation of powers. Today, this separation is being tested. And we're going to hear tonight from two very well-known and very well-respected constitutional scholars, Robbie George and Jeff Rosen, on the challenges that the Supreme Court faces in the upcoming term, including the challenge of its independence. So I'd like to invite our moderator, the Honorable Gene Pratter and Robbie George and Jeff Rosen, there's Jeff Rosen, to come up here and get mic'd up while I introduce our moderator. So moderating this discussion is going to be the Honorable Gene Pratter, a federal district court judge in the Eastern District of Pennsylvania. Born in Chicago, Judge Pratter received her bachelor's degree from Stanford and her law degree from the University of Pennsylvania, not too shabby. And prior to becoming a judge, she practiced law at the firm of Duane Morris for almost 30 years, and she was the firm's first general counsel. So please join me in welcoming Judge Gene Pratter, Robbie George, and Jeff Rosen.
Well, it's definitely my honor and great pleasure to be with you all this evening. Any opportunity to hear from Professor George and the incomparable Jeff Rosen is a treat for me and for all of you. Let me introduce our two scholars here. Robbie George is the McCormick Professor of Jurisprudence and the Director of the James Madison Program in American Ideals and Institutions at Princeton University, which I think is the Stanford of the East. He's served as the chairman of the United States Commission on International Religious Freedom, and before that on the President's Council on Bioethics, and as a presidential appointee to the United States Commission on Civil Rights. He is indeed an acknowledged political philosopher and public intellectual, and he is a great friend, I'm told, of the Union League, as well as the Legacy Foundation. I should say that my younger brother, who lives out in California, and I think is live streaming tonight, hi Mark, told me, in his estimation, I went up a couple notches when I told him I was going to be sharing the stage with Professor George. So thank you for that. Jeff Rosen is the President and Chief Executive Officer of the National Constitution Center here in Philadelphia, as I'm sure you all know. And the Constitution Center pardon me, is an organization whose mission is, in fact, to educate and to expand the appreciation of the United States Constitution. Jeff became the president and the CEO in 2013. We were thrilled to have him as a neighbor at the courthouse, about a block from the courthouse, because he has developed the center's deservedly acclaimed interactive constitution, which does bring together the top thinkers, conservative and liberal legal scholars in America, to discuss in a civilized and productive way areas of agreement and disagreement about every clause in the Constitution. Jeff is also a very great friend of the Legacy Foundation and is a member of the Union League. This evening does present a double bonus for all of us in hearing these two gentlemen, all within the ambit of the Legacy Foundation's mission to inspire and educate not only the members of the Union League, but students and members of the wider community to be respectable and respectful citizens guided by the Constitution. We recently celebrated, you may not have seen this, we recently celebrated the 234th anniversary of the publication in a New York newspaper of the first of the 85 essays by Publius, of course, the pen name of Alexander Hamilton, James Madison, and John Jay. These essays, of course, became and were the Federalist Papers, by which the advocates for a stronger national government hoped to persuade the citizens that the Confederation was not the way to go. Apropos of tonight's focus on the Supreme Court, and perhaps by extension, the federal judiciary, at least one of my colleagues is here tonight. And so I want to speak on our behalf, the lower courts a bit. Perhaps by extension, we are talking about the whole federal judiciary. As you know, Hamilton in Federalist 78 explained that Article 3 of the Constitution set out for the federal courts the job of determining whether the laws of Congress are constitutional. This, of course, prompted concerns that the Supreme Court might become, here's that dirty word, activist, for which there were no structural or guardrails or remedies. The discussion at the time posed the question, should the Supreme Court instead be a branch of Congress, something akin to the House of Lords in England? Hamilton's response in Federalist 81 was to try to assuage the doubters by describing the judiciary as the weakest of the three branches, because it had, here I quote, it had no influence over either the sword or the purse. It may truly be said to have neither force nor will, but merely judgment. Now, with apologies to Hamilton, his elegant observations about judges being without sword or purse, but limited to the force of their judgment, did remind me somewhat irreverently and, in fact, perversely, of the decidedly less eloquent quote attributed to that famous philosopher Al Capone, who said, "You can go a long way with a smile. You can go a lot farther with a smile and a gun." I'm sorry, gentlemen. So even though a newspaper in New York was the first to be able to publish something of the Federalist Papers, recognizing that the confidence in the Supreme Court and the courts today is a subject of such unrestrained animosity and the calls for deconstruction, I looked for a topical news account in a Pennsylvania paper. Here is the sample of the one I read. It needs no argument to show that the Supreme Court of the United States has degenerated into a mere partisan and sectional instrument. The lamentable fact is palpable and undisguised. Its recent outrage upon public decency and propriety, enforcing upon the country a series of opinions not required by the case under consideration and uttered for the sole purpose of giving a certain sacredness to the greatest partisan outrage ever committed by Congress, shows the extent to which the court has degenerated and the utterness of its prostitution to the uses of politicians. Is there no remedy for this debasement of the Supreme Court? We have reason to believe that the subject of a just and fair reorganization of the Supreme Court will be brought before the next Congress and will become a topic of the most serious and earnest discussion. I have just quoted from an article published 164 years ago in 1857. This is a publication with which I was not previously familiar, in the Pratter Journal, which was published in Potter County, Pennsylvania. Robbie, Jeff, how would you each lay the foundations for why today, 164 years later, we are reading the same editorials and hearing about polls reporting that 34% of Americans say it might be better to do away with the Supreme Court altogether. You can, which of you wish to start off?
Well, first, I want to say what a pleasure and honor it is to be back at the Union League. I am, Judge, a friend of the Union League. I'm proud to be a friend of the Union League. And you've invited me here for so many occasions to give a Lincoln Day address, to interview Justice Scalia, our late friend Justice Scalia, and to do so many other things. And it always is an honor. And Judge, it's an honor to be on with you. Tell your brother the check's in the mail. And a very special honor to be on with my dear old friend, Jeff Rosen. Jeff has built the National Constitution Center into a national treasure, and treasure for Philadelphia, of course, as well, but really a national treasure. I want to say thank you. Well, Judge, let me start on your very apt question. The Supreme Court is controversial because it handles controversial matters. So it's inevitable in our constitutional system, playing the role that it plays. It's going to make some people mad by deciding some cases in ways that they don't approve of. And sometimes it will decide whole series of cases in ways that a lot of people don't approve of. And they're going to be outraged, not only that the court, in their opinion, got the decision or decisions wrong, but that the court is partisan, the court is corrupt, the court is ideological. Now, I say all that not simply to dismiss it, but to say sometimes that is false and a slander against the court, but sometimes it is true. And it was true in 1857, when the Potter Journal launched that fusillade of criticism against the court. The court had just handed down its decision in the case of Dred Scott against Sanford, not only holding that Congress lacked the power to prohibit or restrict slavery in the federal territories, which would have been controversial enough, problematic enough, but taking the additional step of opining on an issue that did not appear to be before the court. This goes to the content of what the Potter Journal's criticism was, and that is the question of whether Black Americans, even free Blacks, could be citizens of the United States with the right to bring a case in federal court. This outraged not only hardcore abolitionists, it outraged Republicans across the political spectrum and even some Democrats. They were outraged, again, not only that the Supreme Court got the decision in their opinion wrong, and certainly in my opinion wrong, and on this one, to the extent that we can talk about judgments of history, in the judgment of history wrong, not only made a mistake, but vastly overstepped the scope and limits of its own power, inserting itself into an issue, the most morally divisive, the most incendiary issue of its time, and taking the issue out of the political domain, away from the people and their elected representatives, usurping their authority and thus undermining the spirit of Republican democracy. So I can completely understand the sense of outrage that people who were opposed to the Dred Scott decision felt. Now, that doesn't mean the court is always wrong when it makes a controversial decision. The Brown against Board of Education decision, desegregating our schools in the South where we had de jure segregation, that decision was correct from a constitutional point of view, not simply from a moral point of view, constitutional point of view, correct. And yet, of course, it was intensely controversial. In the South, there were demands that Earl Warren be impeached. Let's do something about the Supreme Court, because the Supreme Court is out of control here, out of line. People who held that opinion were echoing, this time I think in the wrong cause, the opinions of the critics of Dred Scott in 1857. And of course, we have seen in our own time, in the abortion decision of Roe versus Wade in 1973, and in other decisions, the same sense of outrage by critics of the court's opinions. Now, in all of those cases, of course, the country was divided. They weren't united. There were people who celebrated and praised the Dred Scott decision. There were people who celebrated and praised the Brown versus Board of Education decision, people who celebrated and praised the Roe versus Wade decision. But what I think it does tell us, and I'll close and turn this question over to Jeffrey with this, I think what it does tell us is that when you go into the business that Judge Pratter is in, you better put your armor on, because no matter what you do to make the decisions you will be called on to make, you are going to get heat. You're going to be criticized. You're going to be accused, rightly or wrongly, of overstepping your authority, trampling on the democratic process, setting yourselves up as a super legislature that trumps the right of the people to govern themselves. My advice to judges, so Judge Pratter, for what it's worth, my advice is you got to factor that stuff out. Don't ask what will the consequences be, what will people say. Your job, you swore a solemn oath. You know, Justice Kagan and Justice Alito and Justice Thomas and the other ones at the top swore a solemn oath to the Constitution. And they've got to give the ruling on the Constitution that they honestly think is required and factor out all the criticism that you're going to get.
Jeff, should the court avoid incendiary issues deliberately?
That's right.
Should the court avoid what Robbie has called incendiary issues?
It can't. It can't do that. So the question is.
So what's the role of the judiciary?
You know, let's just jump. I'm going to jump right into the question. The court. First, I want to say what an honor it is to be here with you, Judge, and with you. Professor George, Robbie George, has been such a wonderful teacher to high school students during the pandemic. He's jumped on Zoom and joined the Constitution Center's Constitution 101 classes and is our most popular teacher because the light that he radiates to students of all ages and his love for teaching the Constitution is palpable. It's also, I must take a moment to give thanks to the blessed memory of Jack Templeton, who endowed this lecture series. Jack made the interactive Constitution possible. Judge, you mentioned the great achievement of the Constitution Center in launching this online platform that brings together the top liberal and conservative scholars in America to write about every clause of the Constitution. It was Jack's vision. It's now gotten more than 50 million hits.
Oh, wow.
It's the most Googled Constitution in the world. And it has become a platform for nonpartisan learning about the Constitution that has just surpassed all of our expectations. So applause and thanks to Jack for his vision there. But let me try to channel the spirit, all the light, the spirit of Jack Templeton and Robbie George and Judge Pratter in answering this tough question we're here to tonight. The court is about to hear the most controversial questions in a generation next week. On December 1st, it's going to hear the Mississippi abortion case, and may, after more than 30 years of debate, possibly overturn Roe v. Wade. And it's also about to hear a really important Second Amendment case that could change the meaning of the Second Amendment and dramatically increase protections for the right to bear arms. So, and it will delight some and upset others, regardless of how it comes down, but just descriptively, and I think that's the best role that we can both play here tonight, as I know we're doing. If the court overturns Roe and vastly strengthens Second Amendment rights, it will face a challenge to its nonpartisan institutional legitimacy such that it perhaps has not faced since there were calls for court packing during the New Deal. There have been only the court decisions are often controversial, but there are just a couple moments in our history where the opposition to judicial decisions has been so great as to lead to calls for court packing. The election of 1800 was won, and the outgoing Federalist literally changed the size of the Supreme Court to deny the incoming Jeffersonians the ability to make any appointments, and then canceled the Supreme Court term for 2 years so that Jefferson couldn't appoint anyone. And then, of course, around the time of the Civil War, the size of the court changed, and the Reconstruction Republicans reduced the number of justices to deny Andrew Johnson the ability to make any appointments. And then, of course, we had 1936 and the efforts to expand the court, which Democrats in Congress repudiated because they thought that it would politicize the court. And today we have the Biden Supreme Court Commission, which is sufficient, there's sufficient discomfort by both liberals and conservatives with the idea of packing the court, that the commission has refused tentatively to endorse that. And I'll just come right out and say, as the late Justice Ginsburg did, and as Justice Breyer has, that I think this bipartisan consensus is correct. Packing the court would lead to a spiral of each party coming in and expanding the size of the court, and we could have 40 justices, and we'd have a completely politicized court that would have no institutional legitimacy. Nevertheless, Robbie picked some cases that everyone agrees were right or wrong in retrospect. Brown's rightness is unquestioned. Dred Scott's wrongness is unquestioned. But Roe's rightness or wrongness is not unquestioned. There are very strong arguments on both sides of this case. And the question is even more complicated by the fact that even justices who think it was wrong in 1992 reaffirmed it, and therefore our new justices need to grapple with the weight of precedent. Even if a decision is wrong, if it's been reaffirmed so many times that people have structured their lives around it, they've come to rely on it. There have not been changes in facts or law since the decision came down, and the decision is workable. Those are the three tests the court laid out in 1992. The general rule is you uphold the decision even if it was wrong. Now, I'm not going to presume to tell you how to think on this, but I will say I'm teaching constitutional law this term, and we're having a fascinating experience that we call slow constitutional law of reading the decisions aloud. And we read Roe aloud, the majority and the dissents, and the Casey decision and the decision since then. And I can just share with you the fact that my students, after having listened carefully to the arguments on all sides, believe that there are strong arguments on all sides of this case, that it is a very difficult decision. First, what to think about whether the Constitution protects the right to choose abortion in the first place, and second, whether the decision should be affirmed if you think it was wrong in the first place. Now, I just want to focus our discussion, and maybe I'd love Robbie's thoughts about this. Here, let's think about this. Chief Justice Roberts cares a lot about the institutional legitimacy of the court. I know this because right at the end of his first term, right after he was appointed, I had an amazing opportunity to interview him about his vision for the court. I was writing a book. It had the adventurous and brilliant title, The Supreme Court. It was a companion for a PBS series, and he liked PBS, so he agreed to talk to me. And he said to me, Professor Rosen, I have to share with you the fact that most of my predecessors have been failures. It's striking to think that there have been few successful chief justices, and too many have presided over courts that have been ideologically divided based on justices who act more like law professors than members of a collegial court. He said, I think it's bad for the court and bad for the country to have 5 to 4 decisions along partisan lines, and I'm going to make it my mission as chief to try to persuade the court to converge around narrow, unanimous, or nearly so opinions that avoid contested questions. That's his vision, and his model was John Marshall, his greatest predecessor, who converted the court from the weakest branch to one of the strongest, or a co-equal branch, by nonpartisan unanimity. So Robert said he was going to try to do that. I think that he's done a remarkably successful job under circumstances that would have tested Marshall. Unanimity rates have been high. His zenith was June 2020, when Justice Kennedy was replaced by Justice Kavanaugh. Roberts was in the majority 98% of the time, the highest rate since any chief since Charles Evans Hughes during the New Deal. He was the first chief since Hughes to be swing justice and chief justice. And he was able to do this because Justice Kavanaugh shared his commitment to nonpartisan legitimacy, and with the liberal justices, joined him in a series of narrow unanimous decisions. We saw a few of them just last term in the free speech case about the cheerleader who cursed on Snapchat, and the religious freedom case coming out of here in Philadelphia, where the court came up with a technical solution to protecting religious liberty of the Catholic social services that avoided a contested question. This is a long way of saying that, I'll just be provocative, and you can throw it back to Robbie or.
No, we want you to be
But I will say that Roberts, what will he do about Roe? Well, I had the honor and privilege of a bunch of conversations with the late Justice Ginsburg, which I collected for a book called Conversations with RBG, and I asked her repeatedly, what's going to happen to Roe? And she said, as long as Chief Justice Roberts remains chief, it will be affirmed, because he believes strongly in the institutional legitimacy of the court. And he thinks that the fact that it has been reaffirmed so many times makes it a strong precedent, and he doesn't want to see it overturned by a 5-4 vote. Now that, of course, presumed that she was on the court as well. Now she's been replaced by Justice Barrett. We don't know Justice Barrett's views. We do know that Justice Kavanaugh has expressed some sympathy for this vision of pragmatic institutional legitimacy, where he's joined the chief in avoiding contested questions. So if Chief Justice Roberts has his way, I would imagine some sort of decision that would not overturn Roe. And that could happen in a bunch of ways. You could have a 2-page decision saying that you could say the Mississippi law bans abortion before 24 weeks, therefore it's inconsistent with Roe. You could say Roe sets out an undue burden test, and this represents the 16 weeks is an undue burden. End of story. We're not going to say any more. Just leave everything else undecided. You could say we reaffirm the undue burden test, but that 16 weeks is not an undue burden, so we're going to move the line back. Or you could overturn Roe and say you can have restrictions throughout pregnancy. Chief Justice Roberts, all I will venture to predict is that he would prefer one of those, the first two options, one that does not overturn the undue burden test and either affirms the Mississippi law or strikes it down, while preserving the core of Roe. And then the final thing I'll say is I think he's right to do that, because I think that he understands that institutional legitimacy is an important factor for the court, and that in order for citizens to accept the court's judgment as something more than politics, they need to converge around decisions that citizens of different perspectives can agree is rooted in law rather than politics. I'll leave it at that. And
speaking of politics, I mean, my friend and colleague, Judge Padova, who is here, I'm sure is sympathetic to this as well. Nothing really riles judges quite as much as hearing or reading that Judge so-and-so, comma, appointed by President so-and-so, comma, ruled, thus and such. What are the public misconceptions, Robbie, about the Supreme Court and the rest of the judiciary in terms of the so-called political roots from which we've sprung?
Well,
there are many public misconceptions. I'll set up that prejudice of mine.
well, you're going to have to forgive me, Judge Pratter, for being honest, since you asked me.
Well, in my world, we say, well, it's better to be honest.
Okay, good. I'm glad. I've been teaching constitutional interpretation to undergraduates for 36 years, and sometimes teaching constitutional law related courses to law students, especially in the case of undergraduates. The common experience of my undergraduates is to read some opinions for the first time, famous opinions, and to be shocked at the fallacies, the evasions, the poor reasoning, the lack of a grasp of the actual underlying facts, the manipulations.
We've been reading appellate courts.
Yes, that's right. That's true. She's telling the truth. That's right. But some of them are probably watching on the live stream, so I'm in trouble. I'm in trouble now. And it's because the students imagine, especially in the case of Supreme Court justices, that these are gods. These are gods. These are legends. They're down, from Mount Olympus. And they're brilliant. That's how they got on the Supreme Court, by being brilliant. And so they expect to read really brilliant opinions. And often they find themselves saying, gosh, I'm just an undergraduate. This is my first time reading cases. This is my first course in constitutional law. And I can see the non sequitur. I can see the contradiction. I can see the fallacy. So the misconception that the judges are brilliant, that they're not political, that their political views don't enter in, we're just, as Justice Roberts likes to claim, we're just the umpires who call the balls and strikes. That doesn't last 3 weeks. It doesn't last 2 weeks in an introductory constitutional law case. It's just the way it is. It's a misconception. Now, there's another misconception going the opposite direction. I don't find it as much with students, but I find it with people generally, with the public generally, at least the really politically engaged part of the public. And it'll shift sides depending on whether the court is leaning in the leftward direction or leaning in the rightward direction. And that is, this court, whatever this court is at the moment, is so utterly politicized that they never actually resolve cases based on the law. They're never the umpires. They're never just calling the balls and strikes. They're always pushing an agenda. Both of those are out there. The court does not benefit, obviously, from justices do not benefit from the second one. I do think that the court's legitimacy is important, but I would go back to my closing comment and responding to the first question, that I don't think it's proper for the judge, the Supreme Court justice or other judge, appellate judge, to try to resolve the case or to allow to bear on the case the possible public reaction and how that will affect the court's public standing. That's not what they took an oath to do. They took an oath to the Constitution to interpret it faithfully. Now, having said that, I do agree with Jeff. I think he's right that in our system, precedent does count. But that's something really independent of the question of whether public opinion will be enraged or be happy about a result one way or another. So I think that the court should look at the precedent question. We could go into the question of how that bears on Roe. And of course, different justices have different ideas about how to handle the precedent question. And those don't necessarily break along ideological lines, which is interesting. So I think there is a place for precedent, but I want everyone to keep in mind that's distinct from the question, what will the public reaction be and how does that bear on our legitimacy as an institution?
But then what are the public misconceptions about the judge's job? When we were chatting before the program started, Jeff and I were chatting about, does a judge's background foretell the outcome of a case? And I have routinely told people, look, take 100 opinions, erase the name. You cannot decide which was decided by a woman judge or a male judge or a Republican appointed judge or a Democrat appointed judge if it's a blind taste test. Well, but the public is not so sure about that.
To address that question, I have to discuss Jeff's job. This is the job where Jeff is our national leader. We are suffering, and we have for many decades, this is not new, from poor quality civic education. And one of the places that shows up most vibrantly, most vividly, is this. The Supreme Court hands down a decision. You read it in the newspapers or at your favorite website or whatever, and suddenly you learn that Supreme Court handed down a decision on abortion, on gun rights, on religious freedom, on death penalty. And the typical American will either say hooray or boo, depending on whether they like the policy that will either be upheld or reversed by the decision. they don't ask themselves the question that a person with a proper civic education, someone who spent some time at the Constitution Center, would ask, which is not, do I like the policy? But rather, did the court act in conformity with the Constitution? Did the court interpret the Constitution properly? A proper constitutional decision may or may not uphold a policy that I like. A proper constitutional decision may leave in place a policy that I don't like. I may be someone who is fanatically opposed to the death penalty on moral grounds or religious grounds. And yet, if the Supreme Court upholds the death penalty on the ground that, well, the due process clauses of the 5th and 14th Amendments seem pretty clearly to allow for the death penalty. It doesn't require states to have the death penalty. It doesn't require Congress to have a federal death penalty for any crimes, but it allows it. Then I would say, look, my job is to work in the legislatures, in the state legislatures, in the Congress to abolish the death penalty, but the court did the right thing here in upholding the constitutionality of the death penalty. Now, you may disagree with that constitutional, I'm using it just as that constitutional judgment on death penalty, just using that as an example. We Americans need to get past the idea that our favored policies are the ones that the Constitution requires, and policies that we don't like are unconstitutional. Those are separate questions. And the challenge for civic educators, me as a college professor, Jeff running the Constitution Center, is to try somehow to get that across to people. So when they read that headline in the New York Times or at their website, Supreme Court hands down this decision on abortion, that decision on gun rights, they don't boo or cheer depending on whether they like the policy.
I'd like to return, Jeff, to your reference to the President's Commission for a minute. Do you think the commission itself might be an intrusion on separation of powers?
No, I think it's a way of Biden pushing the ball down the road for a problem he doesn't want to confront, which is court packing. And I think that it'll make some recommendations which will likely be ignored.
So you think it'll die a death?
I do, but I want to say that it's significant what proposals were embraced by the commission. And they're the same ones that the National Constitution Center found when we convened 3 teams, liberal, conservative, and libertarian scholars, to draft a constitution from scratch. This was the great idea of Jeff Yass here in town. And he said, why don't you just hold a constitutional convention? So in the state of nature, or the state of Zoom, or whatever it was, these 3 teams got together. And to our incredible astonishment, the conservative team included the most distinguished conservative scholars in America, including Professor George. And the progressive team and libertarian teams were similarly distinguished. What blew our minds, what surprised everyone, was that the progressive and conservative teams, without talking to each other, both proposed term limits for Supreme Court justices of 18 years. And both proposed some sort of electoral college reform that would have embraced a national popular vote instead. We didn't expect this. And it's so interesting that we're reconvening the teams. And in May 2022, the 234th anniversary of the time that the framers convened in May in Philadelphia, the teams are going to come back in person. I hope you can make it, Robbie, in person.
I've signed up. I did the doodle poll.
It's amazing. We'll see if we can actually agree, if they can agree on the language for amendments. And if they can, it would be extremely significant. What does this show us? First, that there is far more ability to deliberate thoughtfully about issues when you do exactly what Robbie suggested, and what we do in all of our Constitution Center work is insist that citizens separate their political from their constitutional views. That is indeed the core of nonpartisan civics education. I begin every class, every podcast, every program with that injunction to citizens, which is the same one I give to my con law students. Separate your political from your constitutional views, as Robbie George said. In other words, don't ask, do you think gun control is a good idea as a policy matter, but does the Second Amendment allow or prohibit it? And open yourself to the possibility of reaching a constitutional conclusion that diverges from your political views. You might think gun control is a terrible idea, but the Second Amendment allows it, or you might think it's an excellent idea, but the Second Amendment forbids it. And by taking that switch, that question of not what the government should do, but what the Constitution allows or forbids it to do, then you open yourself up to the possibility of uniting or respectfully disagreeing around shared principles. Now, how do you do that? How are we doing it at the center? And we're on a mission, and I want to tell you about it so you know exactly how ambitious this mission is. And that is to inspire citizens and people of all ages and backgrounds across America to increase their awareness and understanding of the Constitution by viewing issues in constitutional terms. So every week I have the incredible experience of hosting this wonderful podcast, We the People, that brings together the top liberal and conservative thinkers to dig into these hard questions we're talking about today. Should Roe be overturned? Does the Second Amendment allow or prohibit open carry? Last week was the anniversary of the Gettysburg Address with some great historians. This is an inspiring enterprise because I'm always heartened and surprised by how civil the conversations are. People never are disrespectful, and there are always surprising areas of agreement too. But here's the catch. It takes time. It takes about an hour to really thoughtfully put on the table the arguments for and against overturning Roe. Those are complicated arguments. You can't do it in a snapshot or in a Snapchat or in a tweet. And as Robbie George said, if you just make an instant decision about whether something's right based on the headline, you're not going to have done your civic duty, which is to take the time to learn about the topic, to read the text of the Constitution, study the precedents, listen to the arguments on both sides, and then open yourself to the possibility of embracing a result that you might disagree with as a policy matter. It takes time. It doesn't take years, just an hour. So for, at least to begin to get a handle on this. And you can do it in a class, which is why these hour-long Constitution 101 classes for middle and high school kids are so inspiring. And you put Professor George in front of a middle or high school group, and in an hour, he can open up the world, just teach them a way of thinking about the Constitution that's not rooted in politics. So I'm optimistic, actually, about the future of nonpartisan civics and about the future of the Supreme Court, as long as people take time. But here's the only thing I'm really concerned about, not that commission, which is going to go away. I'm concerned that all of us, not just our kids, but you and me too, have lost the habits of taking time to do deep reading and listening. And I had a very sobering moment recently with our friend Akil Amar, my great teacher in law school. And I asked him, why was it that the standard of debate was so much higher in the founding era than it is today? People in the newspapers were debating issues in such rigorous terms. What's changed? And he said, Jeff, the problem is that people don't read anymore. My own students at Yale Law School don't read. Can you imagine if those brilliant students at Yale Law School are not taking the time to read? How can we ask our, people who have far less advantages and privilege to do that? So what we can do is start by being strict with ourselves. And I find every day just the discipline of setting aside the phone and not surfing and browsing, but instead doing some deep reading is very stretching, and you can grow in wisdom. And we can model it for ourselves and model it for our kids and just encourage everyone to do it. We're not going to solve this civics problem unless we take the time to listen respectfully to each other. And if we do that, I am optimistic that the Constitution will survive.
Well, Judge Pratter, can I just comment
Sure,
on that last point of Jeff's, because I want to drive it home. It's really important. And again, if I can just speak here from my own 36 years of experience teaching constitutional interpretation in Princeton, we have with us Monsignor Thomas Mullally, who's not only a priest, but a lawyer, and was the chaplain at Princeton and taught with me in my constitutional interpretation class as one of our section leaders. So he'll understand what I'm talking about here. So this particular course, which I inherited from a line of very distinguished constitutional scholars, going back to Edward S. Corwin, the greatest constitutional scholar of the first half of the 20th century, has always had a reputation for rigor. It's graded to a very rigorous standard. We've had no grade inflation. It's given me the reputation as the guy at Princeton running the one-man war against grade inflation. And it's demanding. We demand that the students master the most challenging legal and philosophical concepts that are pertinent to constitutional interpretation. It's a tough course. And naturally, as a result, there's self-selection, and we get really the best students who are willing to tackle the course. Unless you're a first quality student, you're just going to stay away from this. So I have been able to hold the line on the grading. We no grade inflation. You know, there's still such a thing as a C and a C minus and even a D in constitutional interpretation, believe it or not. We hold the line on the concepts that we expect our students to master. We're able to hold the line on that.
So not everybody's above average.
Exactly. We're not like Lake Wobegon. We're not like Wobegon. But, you know, even an old timer like me has had to yield on what? The quantity of the reading, Jeff.
Hmm.
Even I had to finally give it up because I realized about 7, 8 years ago that the students were not doing all the reading. And if they were going to read selectively, it became clear to me, if they weren't going to read it all, they were going to read selectively. I wanted myself to be making the decision what do they read, not them making the decision. And you have some kids who've read this and some kids who've read that and so forth. So I've had to cut back. And it, I think, has to do with the narrowing of the attention span of our young people. And there's a real cost to that. It's a failure of education, not just in constitutional law. It's harming education across the board. I don't know what to do about it. The social psychologist Jonathan Haidt blames social media, and maybe that's right. But whatever the cause is, we've got to fight back. We've got to find a way to push back against this. We need our young people to be reading again.
Well, before I turn to the tough questions that have come from the audience, let me ask a little bit of a softball to you both. To what extent do you think the justices of the Supreme Court have contributed to some of the negative attention by appearing on talk shows and writing books and opining on everything, including to the point of even becoming a bit of a cult figure?
Now, who would that be?
It could be any of them in some respect. I just know it's not Judge Padover. And by the way, why in the past was it thought the judiciary would be expected to be seen but not heard except through their opinions? Either of you.
You know, I started writing about the court many moons ago in 1992 for the New Republic magazine, which at the time was one of the few places that wrote about the Supreme Court. And there was no internet. And a couple of the justices, it was unusual at that time for the justices to grant interviews. And the norm has totally changed. I used to think that it was a very bad idea for the justices to speak to any journalist except me. Mitchell was an exception, but as long as otherwise, definitely not. And more broadly, though, there's you know, sociological finding that mystery breeds authority. And when you have the black robes and the impersonality, then, and justices don't act like celebrities where people think that they know them, they're more likely to respect the nonpartisan adjudication of the rule of law. So that's the case against justices speaking to the public. But the cat's out of the bag. I mean, now all of them. It's remarkable how, and it has changed fast actually too. Even in the past 5 years now, all of them are giving some lots of speeches and writing books and writing memoirs and so forth. My sense is when justices speak in the role of teachers, then they're performing a service of public education when they help explain how the court actually works. So Justice Breyer was on our Zoom for the kids in a few months ago. And he was speaking in his wonderful way so candidly about how justices actually decide cases. And he said, it's not all politics. It's about methodology. You have to understand the methodologies. And I pressed him. I said, but you know, sometimes you see this connection with the politics. He said, well, political philosophy might matter. It's if you're a Maoist socialist or an Adam Smith capitalist, that could influence you. I said, well, what's the difference between politics and political philosophy? And he said, well, you'll have to ask Professor Tribe. You know, that was a tough question. But that kind of grappling is okay. But you know, when justices make partisan statements, and the real, I guess I'll close this thought by saying the real danger is talking to the home crowd. When the liberal justices only talk to liberal audiences and the conservative justices talk to conservative audiences. That's not good for nonpartisan legitimacy. It's of such a delicate balance because it's a very important question, Judge, because every other branch of government has become so polarized and Twitterized and is playing to its base. And you see our presidents tweeting, which would have been the founders' nightmare because they didn't want direct communication between the presidents and their constituents. So when you have justices playing, Justice Ginsburg used this phrase, to the home crowd, to their base, that is really bad for the nonpartisan legitimacy of the court. But if they can, go on to mixed audiences and talk about their reasoning in a nonpartisan way, I think it's okay.
Robbie, do you have a thought on that?
That all makes sense to me. I like the idea of judges teaching. Many of our justices, Justice Breyer is an example, Justice Scalia was another, actually do summer teaching and teaching for law schools on the side and so forth. I think the important thing is, A, that they avoid commenting on cases that are pending or that may or will likely come before the court. I think that is a really important principle. I don't think that one's been badly compromised yet, but I'm worried about the direction things are going. And if that gets compromised, I think we're in trouble. I like the idea of the public getting to know a little bit more about the minds of the justices, who these people are and how they think. I mean, after all, for better or for worse, rightly or wrongly, much of what the regime of law we live under is judge-made. We can talk about the extent that's good, the extent that that's bad, the extent it's legitimate, the extent it's illegitimate. But if the American people are going to live under rules that are largely made by those people, rather than the people across the street at the Congress, they should at least know who they are and have some sense of what makes them tick. So I'm all for that. Now, having said that, at the same time, something I don't favor is cameras in the courtroom. I think the court has been right to stay away from that. I don't see anything but mischief actually coming out of that. And I agree with Jeff that when the justices go out to speak, they should avoid, to the extent they possibly can, associating exclusively with one ideological camp or the other. Now, that might not be their fault when it does happen. It might be that Justice Breyer is never invited by conservative groups or Justice Alito is never invited by liberal groups. And here I would just encourage the American Constitution Society to invite Justice Alito and the Federalist Society to invite Justice Breyer. I do think actually the Federalist Society has been quite good about having the liberal justices be invited. But I do think that's important. But again, when they do that, they still need to remember that they are judges and not politicians. They shouldn't be advocating anything that would be pertinent to any case that is before them or might come before them. Now, they can advocate their judicial philosophies. This is fine with me. I have no problem with this. So when Justice Scalia and Justice Ginsburg, if I recall correctly, were on C-SPAN debating whether the Supreme Court should or shouldn't take into account international law.
Oh, you read that. I've got it right
decisions.
here.
I thought that was a perfectly legitimate debate, and that each of them was in the right to advocate his and her positions there in the public. That was not directed to any one particular case. Now, there were some cases that had been decided where international law was invoked by some justices who were criticized for it in dissent by other justices. So there were cases in the background, but they weren't actually arguing out a case there. It was a general principle on which reasonable people of goodwill disagree, reasonable jurists disagree, and I think the public benefited from that C-SPAN experience. That's fine with me.
Well, seriously, this question that came from the audience was, what role, if any, should international precedents have in deciding or being used by the United States Supreme Court justices? It was right there.
Well, I'm on Scalia's side, not much.
Not much.
We didn't elect, the parliament in Brussels or the UN or.
Okay, well, this one is tough for both of you. You can turn into prognosticators here. What do you think the next amendment to the United States Constitution will be?
Well, this team
Yeah, sure, yeah.
suggests that the term limits amendment has more current support.
But only
although
for the Supreme Court or for
Yeah.
others as
Just for the
well?
Supreme Court,
Ah.
and it's tough to implement. Now, our friend John Aguilar is here, and the idea of a term limits amendment has some support as well, and was making some progress in the states, but probably not enough to get over the 3/4 hoop anytime soon, but hope springs eternal. And the next most popular one is the balanced budget amendment, which was close, but not quite, no cigar yet. And then, of course, the ERA, some argued surpassed the 3/4 threshold, but some states have withdrawn their ratification, and therefore Justice Ginsburg felt that it was safer to start again on the ERA. But I think those are the most popular ones, but it's very tough to pass an amendment.
Robbie, do you have a
I think it's term
opinion?
limits. I think it's terms. A balanced budget is controversial. ERA is very controversial. Term limits can be embraced by people on the left and on the right. The argument doesn't depend on anything ideological or any ideological presuppositions. People are living much longer, both men and women living much longer than they did at the time that the good behavior standard, the life tenure standard was put into the Constitution. We have had some experiences with justices who were not, I have in mind in particular William O. Douglas, who lay aside any of the partisan considerations. He was a very controversial figure for his rulings. Lay all that aside. He was suffering from significant cognitive disability toward the end, and he refused to go. And when people, including family members, tried to persuade him to go, a bit of paranoia associated with the cognitive disability caused him to become very suspicious of that and dig in his heels further. So I think, reasonable people on both sides can legitimately be concerned about that. It would also, I think, help to avoid the kind of situation that I think we're headed for, which is the appointment of younger and younger judges with less and less track records of, in the hope that you will control the court, that they will be on the court for 50 years, so that the particular ideological point of view that they're regarded as holding will control that seat for a long
Well,
time.
as you know, in civil jurisdictions where judges are really notaries almost, they come in quite young, having gone to school to be a judge. And that obviously is not the model we've used. Jeff, to close out here and to share the wealth of restructuring a branch of government, as I understand it today, you moderated a program, the title of which was, "Does the Presidency Need Reform?"
Yes,
Just to be fair and share the wealth.
it was just this afternoon
Right.
at noon.
What was the
Friends,
result?
you gotta go on, just sign up for our email. It's so exciting to week after week, these glorious discussions full of light from people who really disagree. So today we had Sai Prakash from the University of Virginia, whose new book is The Living Constitution, the Living Presidency, how it's violated the original understanding of the founders. And Jessica Bowman-Posen from Columbia, who argues that, contrary to Tsai, that the administrative state is not just a presidential power grab that the framers wouldn't have liked, but Congress has fully acquiesced in it. She had a kind of subtle account of its growth. And then Steve Skowronek, one of the most important political scientists, who has a new book out called The Deep State and the Unitary Executive, and said that the two things converged not just under President Trump, but in growing way over the past decades, to create a personalized presidency that the framers wouldn't have accepted. And that was the surprise, that after everyone talked through their disagreements, all three of them agreed a personalized presidency would have been the founders' nightmare. In the same spirit of this idea of personalized judges threatening nonpartisan legitimacy, the president was supposed to be a nonpartisan chief magistrate, not dependent on the demagogic appeal of the particular occupant. So then the three of them were talking about ways of depersonalizing the presidency, and they had some interesting and complicated reforms which you'll have to watch the show to discern. But isn't that interesting that when you think about the question in institutional and constitutional terms, not is Trump bad or is Biden bad, everyone agreed that the expansion of presidential power, I mean, certainly is really got up and going in the progressive era, but in particular, and social media has been a big part of it, the personalization of the office is very much not a nonpartisan thing. And even executive orders, which everyone wanted to know about, have been used increasingly and opportunistically by people in both parties to achieve what they can't get from a polarized Congress. So the answer is always, it's complicated, but the answer is not, it's impossible, because there are concrete reforms that could be identified. Here's the rub, though. They often nowadays would require a constitutional amendment, and now we're back to the second question. Those are very difficult to pass.
Back to the founders, when you've got a George Washington around, you can easily be lulled into thinking you can have one anytime you want one. They don't come along very often. On the point about the expansion, really, of federal executive power, I often tell my students that I think the most overlooked word in the entire Constitution, and I urge you to go to your Constitution. I think there are copies of it over there being handed out. Go to your Constitution and look at this. Look at the very first word of the very first sentence of the very first paragraph of the very first article of the Constitution.